And good afternoon and welcome to this Nyaya Forum and Roots Resources special interview. We have with us today a very special guest, Advocate Nitya Ramakrishnan. Nitya ma'am is really respected and is famous around in the country in the criminal law circuit, and she is well known for the famous trial defenses that she has to her credit, notably the Indian Parliament attack case and the Haren Pandya murder case. She's also the author of the book In Custody, Law, Impunity, and Prisoner Abuse in South Asia, which has been published by SAGE, where she talks about the evolution practice and the politics of custodial abuse and justice in India, alongside various countries in the Indian subcontinent. Nitya ma'am is an inspiration for law students around the country, and all of us look up to her for the work that she has done. Uh, we're really thankful to you for taking out your time today and joining with us for this candid interview so that the people can know more about you, know more about your practice, know more about how your life is around the law and how you move forward in that direction. So we are live on YouTube as well right now. So we shall be even seeing in if there are any questions from the viewers. We have a bunch of questions that we have prepared for you today. So we can go through with those questions first. And after that, if we have any questions from the audience, we can pick that as well. So without much further ado, once again, thank you so much for joining us, and let's start this conversation. The first question that we have for you is, could you tell us what exactly inspired you or got you to study the law and to move forward and make a career in this profession?
First, thank you for all those very kind words. I'm delighted to be here. As to what brought me to law, Mustafa, I don't know whether I was brought to the law or the law was brought to me, but here we both are, and much the worse for the wear. Let me say this, I think different interpretations for the same set of facts, formulations and counter-formulations have appealed to me as an intellectual challenge. I was a student of philosophy, and in some sense, this is a continuation. In some ways, it's a continuation. Principles of deduction, inference, the use of language, text, all of this is common. So that is an explanation. Of course, there are very important differences between the discipline of serious philosophy and the law. But perhaps that's an explanation.
Okay, so moving forward with that, a little bit about what incidents impacted how it has shaped your views towards how you've seen the law. We actually read a short piece that you wrote for The Wire on George Fernandez. And in that you mentioned that the 1977 emergency acted as a political baptism of sorts for you. So how has that helped shape your political views and subsequently shaped how you look at the law and its practice today as well?
The emergency taught us what state power could do. I'm advisedly saying what state power could do. I'm not qualifying it as what unrestrained state power could do or what state power without accountability can do, because the emergency showed us how easy it is for the state to slip away from accountability. Norms and institutions are important, but the emergency also showed us that they may prove entirely ineffective and irrelevant. So soon after the emergency, I was still in college, I think I became a philosophical anarchist. I started looking for anarchism in virtually everything I read, Wilde, Sartre, Kropotkin, Gandhi even. Later wisdom tells me that you don't need a declared emergency for the state to lose accountability. So I think the purpose is always, at least that has been my concern, is how to liberate the individual from the tyranny of systems. And to that end, now I'm turning more and more to Gandhi. So my faith in systems is limited. Systems are as they do, and the law fits in within that worldview of mine. I hope that answers your questions. If it doesn't, I'll try and elucidate further.
And it definitely gives a great perspective to us about how you think about how the systems work in our country today. So obviously, on that leg, moving forward, we would love to hear about how these thoughts and how, as and when these thoughts shaped into your mind, how did it affect and how did it, in a way, shape your practice in the initial years? So once you stepped into becoming a lawyer, how did that come into play, and how were your experiences in the initial parts of your career, and how has it molded as you've moved forward today?
Well, as I said, I was in college during the emergency years. So one was part of movements, of civil liberties movements. One's friends were political. It was a very important time for young India. It seemed to be make or break for us. And then when I moved into law, in my final year of law, one of my close friends, he got arrested for holding a member of parliament hostage because Jhagrak and the colliery in this MP's constituency, the workers were in abysmal state. So this young political activist decided to hold him hostage, and then he was arrested. So as I moved into law, I was concerned with his defense, but not only that. He would refer to me cases of the poor, the indigent, people who suffered custodial abuse in jail, in across many of these cases. So my early years in practice, I took up those cases. Perhaps that's also an explanation of why there is so much of criminal law in my life, though that's not all the law in my life. So there's a Supreme Court judgment, Sanjay Suri, that is a case on jail reform. That came because this friend of mine, Kumari is no more, case of abuse, homosexual abuse of the young prisoners in Tihar. So then we had an investigative report into it. We took it to the Supreme Court. Then some far-reaching guidelines were laid down by the Supreme Court, of course, perhaps only followed in the breach. Then there were cases of police torture. So one of them, I think in my first year of practice, we took to the High Court. The High Court ordered an inquiry by the Chief Metropolitan Magistrate. So we had to establish the case of torture. So some cross-examination came into it. Finally, the sub-inspector was found guilty of torture in the inquiry, but I was trying to find out on what principles I could hold the higher officials responsible. I did not then know the term command responsibility. I learned that term much later. So with these challenges, and those were not days of internet and so on, so one would sit in the libraries and read, and I would walk up to any senior lawyer and ask for advice. So on this, actually, I got hold of Ram Jethmalani in the Supreme Court corridor, and I said, "Sir, how do you pin vicarious liability on the superior officials?" And he, in fact, spoke to me for half an hour. People were really, really helpful. And so we argued on that basis. I read up on Nuremberg trials for that, because the basic principle of command responsibility is there, though it's perhaps not termed as such. And then that was, it's actually part of a judgment of the Delhi High Court, now very old judgment, Satpal versus ACP police. Then, of course, so the political impact on my career was due to acquaintances, concerns, civil liberties, human rights, and criminal law is very, very close to human rights. Other aspects of law, but one single body of law affecting life and liberty is very, very close to human rights. So that perhaps was the impact of the emergency, my political understanding at that point of time. My friends and acquaintances in the civil liberties movement who influenced the early, otherwise who, these were the cases I could do. These are the people who had nobody else to represent them and would trust somebody, a newcomer like me. So that was that. And those were days when, as I said, senior lawyers were very accessible and judges were very nice. And, I used to sit in the judges' library sometimes and work. The Supreme Court library, judges' library. In fact, there was a case, not really a human rights case, but it was strange. Somebody I knew who was working as a journalist, he suddenly came and told me that he'd been friendly with a girl and they'd been separated by the parents. And now he realized that that girl had had a baby and he wanted to claim that baby. So it was not only full of human interest, but full of challenges in terms of the law. So then I sat and I couldn't find anything very much in the Supreme Court library, but I used the judges' library and I found there's a very interesting book called Trevelyan. I think Trevelyan is the name of the commentator. And then I found a case which suited the case to a T, because the girl's parents had made her give the child away, but it was not a proper adoption. So that was a time when non-Hindus could not adopt. So then I found the law moved, the High Court then granted a writ of habeas corpus, gave the child to the mother who later married this man. So, it's just, if I go down memory lane, I'll go on and on and on. So there were interesting influences of this kind. And this is perhaps how criminal law entered my life.
Could you repeat the name of that book which you just mentioned right now? Would it be in circulation for students to refer to right now?
I'm sure it would be, because Trevelyan was a very, very important name. In fact, when I argued, it was before a very, very tough but a very fine judge of the Delhi High Court, Justice T.P.S. Chawla, who was heading that division bench. And I said Trevelyan by mistake. He said it's Trevelyan. And it's one of the biggest authorities you should know. And I said, I'm sorry, sir. So I'm sure the book should be there. It is on perhaps custodial rights in the sense of custody of children, etc. So we found this principle that keeping a child away from the parents, people lawfully entitled to custody, would be deemed an illegal detention. And then that also referred to me to two very other old cases. One was J. Krishnamurthy's case, where he'd been adopted, not formally, but he'd been adopted by Annie Besant. But when he became very famous, his natural father wanted him back before he became a major. And case was fought up to the Privy Council, and the principle was that you cannot keep the child away from the lawful guardian. Because the lawful guardian has both rights and duties, and the child can claim against the natural guardian in a manner that, this is what I'm talking about, early days. So I'm just telling you the excitement of looking for law, looking through books, we couldn't get the law at the press of a button. So if you ask me, and then there were some trade union cases. So this is how I grew in the law, not in any designed fashion, but as I said, it just happened.
Yeah,
but the judges used to encourage us a lot, and almost anybody, I would just walk up to people and ask them for advice in the Supreme Court, and they were all very, very kind to me.
Yeah, it was great to hear your experiences. And also alongside that, we got to hear a lot about the cases which you took up. One aspect, though, which we really wanted to hear from you are the terror trial cases, which, they get really discussed about, which you have represented, people in. So could you tell us your experiences with those terror trial cases, how it was to argue in those cases, how with the background things which took place as and when you defended the people in these cases, how things went about with that, your personal experiences and any anecdotes which you would want to share with us?
That's a very, very wide question. You should hone it a little bit. I'll try and answer it, because, there are personal experiences, there are legal experiences, there are legal perspectives. It's a very wide question, but I'll try to answer. See, the first thing about terror cases is you must understand that they are fought under a social hype situation, the charge of a nation in peril. Even the media, when you're doing the Parliament attack case, even the media was hostile to us. On occasion, I've lost you. Yeah, on occasion, they would stand and say, Desh ke Gaddar Murdabad in Patiala House. That was including press people. So there is that. hype against which you defend, then the laws themselves are not very friendly to the accused. Porta, for instance, had this, admissibility of confessions to police officers, which is the police officer just comes and says this man is confessed. Although in that case, eventually the Supreme Court threw them out. It's a remarkable, that was a remarkable thing that happened. But so these are impediments in a manner of speaking. They're different from other trials. Both the atmosphere and the law, the statute, is somewhat more hostile to the accused, and then bail is impossible. So to fight a defense for an accused in custody to mount a defense, it's such a serious handicap. You know, you're not able to meet your lawyers, talk to them. You have to talk to them in court or go to jail. So these are additional challenges in terror cases. But for that reason, required a different additional application, and it was challenging. And when you succeed, you feel very happy.
Okay, on those lines, a little bit about the criminal law practice in the country. A question that I had for you is that how is practicing at the trial level different from the appellate level? So again, what challenges and real life problems would a lawyer face on both of these different levels of jurisdictions?
See, problems faced are a different thing. The nature of the proceedings are substantially different because the trial is where the record is created. Evidence comes into being. And an appeal, you argue, you apply principles to the evidence and the record that has already been created. So that is the most fundamental difference. In a trial, you have to cross-examine. And I tell you, cross-examination is the most difficult part of lawyering. Most difficult part of lawyering. And that challenge is not there on the appellate side. Having said that, you know, while cross-examining, while engaging with the creation of record, while dealing with the trial, one must always bear the larger principles of law in mind, because that's what will tell you what it is that you want to elicit. Where is it that you want to go? So you have to keep the law, especially the law of evidence, but also the substantive law in mind, because you know where you want to go. And so you have to know what is it that will assist you if you elicit a certain answer. What are the principles you're going towards? What is it that you're going to argue at the final stage? Likewise, while dealing with an appellate brief, it is always useful to know the nitty-gritty of trial court practice, because that way you look at the file, you can figure out what are the procedural irregularities, what are the procedural irregularities you can capitalize on, what are the procedural irregularities that you have to get a cover against. For instance, asking a question in cross-examination or not asking a question in cross-examination may amount in some circumstances to an admission. So you have to bear that in mind when you're dealing with an appellate brief, whichever side you are from. Or in a criminal trial, it's important to train, to know how, if you're for the accused, how to answer questions finally put under 313 of the Criminal Procedure Code. It is often neglected, but it's a very important opportunity which must be exploited. So there is, as I said, the differences in emphasis, differences in the mode, but there is an important link. And it would likely be the same for civil cases also, though in a different fashion.
Okay, so moving forward once again, with respect to your personal experiences again. So as a woman trial lawyer, a woman who's in the criminal law space in the country, so your personal experiences, how have you navigated through this space to make your mark today? And what challenges did you face in moving forward in this entire process?
The only challenge that I recognize while doing a case is the case itself. And I navigated it. I hope I'm right in saying I navigated it by applying myself to the case. I think I navigated that space more as a lawyer than as a woman. Now, I don't know how whether there is a subtext to my statement, but it would be broadly correct that I navigated it as a lawyer, dealt with the evidence, dealt with the principles, did my best. A trial is always a challenge also because, you see, it's not limited to the law and the law books and the statutes. For instance, if there's a witness who's a medical witness, a doctor, you have to virtually become a doctor to cross-examine that witness. If there is electronic evidence, for instance, in the Parliament attack case, there was so much electronic evidence. There was intercepted evidence, telephone conversations, which went contrary to the law under which they were prosecuted, namely POTA. So there was also a certain duplicity in the process because POTA was used to record confessions by police officers, which is otherwise inadmissible under normal criminal law in this country. But when it came to the rigors of the wiretapping code, they were not applied. And the special cell got away with saying that on that day, when we did the wiretapping, we had not invoked POTA in the FIR. Now, if ever there was a terror case, it was the Parliament attack. And by the expedient measure of not invoking it, whether by design or by accident, you deprive an accused of the safeguards that special law provides, but then you invoke that law in time to get police confession. So there is, especially in terror cases, you come across these situations, but then, it's not enough to just lament about it. Your client expects you to do your best, and you have to do your best. Likewise, in the many terror trials in Gujarat, the trials used to take place inside the Sabarmati jail. And we had such the government lawyers used to be permitted to just drive into the jail, but we had to leave our vehicles outside, and to carry the books inside was such a problem. And then the accused would come with wheelbarrows to carry the books. And we had to be, they were in jail, and the trials used to happen in jail. And then there were, of course, challenges. The evidence used to be taken in Gujarati, so I had to learn a bit of Gujarati to understand what happened. And the cross-examination, I would ask in Hindi. And, so there are different challenges, different cases pose different challenges. The atmosphere is also very charged in these cases. You get used to that.
So again, on those lines, you spoke about your initial days of how you, in the Supreme Court library, working on the field, gaining experience and gaining knowledge on how to move forward with your practice. How do you think that is in contrast with how practice takes place today? Now that because we have computers and we have a lot of electronic resources that have taken up the legal space entirely, so the reliance on libraries have gone away. It's more of the e-resources that we rely upon, and even legal education in that way has changed a lot from your days in comparison to today's days for students like me and the ones watching here. So how do you think that has changed the legal system, and how has that affected your practice as a whole?
See, it's a great advantage. I mean, you can sit at home, you can, access these resources. It's a great advantage. Only thing is, a surfeit of data sometimes makes you miss a nuance here and a nuance there, because it is so dependent on a word search that no matter how well equipped that machine is, frankly, I like Indian Kanun the best, because I consider it logically the best constructed, because a wide range of searches, probably because it's designed by scientists, anyway, I shouldn't say more, but so there is a possibility. Whereas if you're sitting and reading a text, it gives you not only an answer to that word search, but it gives you the context. So you'll come across something else that might trigger. For instance, I remember for which case I was researching for for something at that point of time. I was doing an opinion on the Telegraph Act and the right to privacy. And while reading up, I found this proposition that fundamental rights can only be affected by statutory law, statutory rules. It can't be by an executive instruction. It helped me in some other matter. Of course, that might still happen if you're reading up a judgment which you've accessed through SEC Online or Manupatra or Indian Kanun. But that is one difference I feel in the mode of research. But definitely it saves a lot of time. You can sit where you are and you can research, you don't all. But I go back, at least judgments, once I get the citation, I prefer to take the book and read it. Probably it's just it's a function of my generation, not of anything more significant than that. I don't know. Have I answered your question? You were asking such a wide question. I don't know the answer, whether it answered you.
It did, in a way, give us a lot of idea. Also, it told us that, okay, Indian Qanun is something which we should...
I like it. Everybody laughs at me, but I like it.
No, definitely.
It operates on a fuzzy logic. So it's a wide angle. Whereas the rest of them are case within case within case. Anyway, that's not the purpose of the evening, but I really like Indian Qanun.
All right, so a little bit about what do you think and how would you advise law students today who would want to follow your path, or follow the work you have done in order to make a career just like how you have? So what advice would you want to give them on how to build your practice in the criminal law field for terror trial cases and cases of that like?
Mustafa, people who work with me are exacerbated by my animadversions, my constant lectures. But I'm not a great one for dishing out general advice. But since you asked me, let me try. See, one thing I would say, whether you're doing criminal trials, I'll also come to what perhaps they should keep in mind for doing criminal trials, but terror trials. One thing is, please read up generally, read up history, read philosophy, read what you can about science, read politics, to get a perspective, get an academic perspective, especially law schools, which, you go straight from school into law school. That discipline of reading is important, one. Second thing is, while ideology is important, it is important to view law from the lens of patriarchy, from the lens of colonialism and all of that. When you're dealing with a case at hand, don't perennially wear, your ideology glasses. Deal with the facts. Let the facts lead you to conclusions and strategies, rather than trying to twist and turn and fit the facts into your preconceived notions. In particular, acquaint yourself, be ready to be acquainted with areas which are not necessarily your areas of interest. Like I said, if you have to cross-examine a medical witness, you'll have to have the ability to understand medical terms, understand medical processes. So don't limit yourself only to areas of interest, saying, mujhe to science mein interest nahi hai, mujhe physics mein interest nahi hai. That will not work if you want to do trials, especially now, increasing areas. Electronic evidence has come to be so important. Acquaint yourself with the law that you're dealing with, if it is special law or even the, whichever law, but more importantly, acquaint yourself with the procedural law. In fact, I would suggest glance through the contents page of the CRPC. So you know what all is provided for, or if it's a civil case, glance through that. So you know what has been done, has it been done well, what else is provided for, how will you know otherwise? So understand what the structure of that law is about. Likewise, the Evidence Act, you have to be very, very, conversant with the law of evidence. It's such a lovely law in any case. It's a fascinating area of the law. And then I would say, don't despise any area of the law. You might want to be a criminal lawyer, but do not despise corporate law. Do not despise arbitration law, because any law, the application of principles to a fact situation, it will hone your ratiocination. It will teach you advocacy. And this is my fortuitous advice. Eschew verbosity, eschew bombast, pay attention to your language. And I think that's enough advice for one evening.
Anything which you would like to add on the practical aspect? Because theoretically, learning the law, reading the law, but how would you advise students to put that into the practical perspective, actually interning probably at trial courts or working with lawyers? So how should they also work around that? Any advice that you would want to give?
But that you guys are doing anyway, no? See, whether you've interned with a lawyer or you've not interned with a lawyer, if you've got a case on hand, you've got to apply yourself to it. You've got to read up about it. You've got to spend time on it. You'll have to understand differing perspectives on it. You'll have to train yourself for cross-examination. So basically, you have to apply yourself to a case if you're dealing with a case. And no doubt, all this experience which you're saying, interning, but I really think you should also intern. But that's something which is required even for the magistracy, even for the improvement of the criminal justice system. See, everybody interns with lawyers, everybody interns with High Court and Supreme Court judges. But really, it's a magistracy which needs that kind of wherewithal and support and infrastructure. So fancy law schools like yours or Bangalore and LLU, they must have every season, every year, they must have their people reach out to the magistrates, intern with the magistrates, research law for them, because they're really, especially in far corners, maybe Delhi, Bombay is different. Far corners of the country, they're so challenged. How to deal with custodial issues. Arnesh Kumar says the magistrate must check whether the custodial rights and the CRPC rights have all been granted to them. They may not even know of this, or they may not have the time. There should be a checklist. They should engage with a prisoner, especially a prisoner from police custody, to know how the treatment has been. So infusing this kind of young, idealistic people, especially who have the time to prepare this kind of thing, you should also go and work with magistrates, with sessions courts. It's something I've been suggesting to law schools for years. It's, of course, much fancier to come to Delhi and Bombay and work with judges and lawyers. But this is important. This is important from your point of view. It's important from the point of view of the criminal justice system. I don't know. Practically, is there anything else? What else did you mean? Practically?
I think this suffices what we are trying to gain out of this question. But just one thing now, and this is a little bit hypothetical, but obviously this would again open up an entire arena of your thoughts and ideas. If you were to take up the responsibility of making any changes or making some transformations in the trial court system of our country for probably a year or two, what would be the major things which you think need to be worked upon and to be changed in order to make it more effective in nature?
Why 1 or 2 years?
That is not the important.
Is there any purpose to that question? I'm trying to answer you.
It's a very hypothetical question. I just put it up in a fancy way, but like if you
it's not determinative of your question, all right.
That's not the important part. The important part is the responsibility of the trial court system around the country. So, what are your thoughts on that?
One thing first, you mean trial civil and criminal? Shall we restrict it to criminal for the moment? The question?
Yeah, criminal for the moment. Yes,
okay. Yes. See, one is, let's look at the magistracy. One is what I told you, because especially, it has been coming to my notice that people I don't want to mention the name of the state, the magistrates don't, first the high courts will not deal with bail applications unless you've gone earlier to the magistrate, then sessions court. Now, I don't know what the logic is, because when the law decides to give you concurrent powers, why you must insist on this, I don't know, especially in a matter of liberty. Magistrates don't dispose of bail applications, even in cases carrying imprisonments of 3 years maximum, 7 years maximum. So one thing is, as I said, give them the wherewithal. And there should be a specification that bail applications should be decided within a certain limited time. If it is, say, carrying less than 7 years, then I think the magistrate should not be given more than 3 days to dispose of a bail application. The sessions court should not be given more than a week. And the high court should also, especially where the sentence is low, the maximum sentence, not take more than 2 weeks. So there must be a specification of that. The other, I've already said that they must be equipped. They must have a checklist. They must be able to deal with each prisoner who's coming from custody. So they must know what all to ask, how to look at the remand papers, how to grant custody. It should be made clear to them that an accused is not obliged to move for bail, not under 437. When an accused is produced before you, You can release the accused on bail even without an application. You're not obliged to remand. You may just decide not to remand that person either to police or judicial custody. So this will get in there, get into the consciousness only if it is fed into it in some fashion, not just by overarching broad-based principles given by the Supreme Court in each case, but through some infusion of energy. Now, I may not be wrong, but this is an idea that I have. So young people working with them, saying these are the principles, why don't you apply, may help. This is the second thing. As far as magistrates are concerned, then I say the trials. Of course, you have 436A and you have Hossainara Khatun and so many cases, but you still see people languishing in jail despite half term being over. But I see that in special cases like terror cases, where just the allegation is A and B and C conspired to do something, nothing even happened. 10 years, 15 years trials don't get over. And they're in jail because they, UAPA cases and bail is impossible and no judge is ready to give bail. So I say that even for offenses punishable with life imprisonment, there must be a limit. If a trial does not conclude in 5 years or 6 years, then there must be an entitlement to bail. There must be, I would say there must be, if a prosecution witness, a police witness, doesn't turn up on more than 2 occasions. I know the police is overworked, but there must be some standards because liberty is more important. Of course, national security is important, but then, you have fancy agencies working on national security, prosecuting cases, and then for days on end, the witnesses don't come. They take time, they don't come. There must be a limit to how often they can seek adjournments for producing a witness. There's one thing, Mr. Jethmalani once told me that long ago in Bombay, the procedure used to be that once the charge sheet was filed, the prosecutor would come and say, okay, all these pages must go out of the charge sheet because they are prima facie inadmissible. But even today, you see huge charge sheets which is filled with the accused disclosed, accused disclosed, accused disclosed, disclosures not leading to any discovery. On the face of it, inadmissible. And many of the accused are such poor people, it may not even occur to them to have a lawyer, or they may not be able to afford a lawyer, the lawyer may not know. So this enters the stream of evidence somewhere unless the judge is overconscious. So we should have that procedure where as soon as the charge sheet is filed, things which should really go out, not complicated issues of admissibility, but some of these things must just go out of the record. And then in order to reduce the burden on a victim of abuse, either way, of course, victimology says, we have an extensive code under Section 357 CRPC for compensating the victim. But supposing it seems at the end of a trial to the judge that the prosecution is entirely unjustified, the judge should have an option of awarding compensation suo motu without making the accused or former accused go through this process of a tortious process of malicious prosecution and so on and so forth. But having said that, there's a rider I will add, because it's also been brought to my, it's been suggested to me, and I think there's something that it's one thing to acquit in serious cases, but if a judge felt that she may need to make a judgment on whether it was malicious or not, then maybe less inclined to acquit. Now, I don't know, it may be true, not, but in principle, I feel that such a provision must be there. I don't know. Immediately, I don't have any more brilliant suggestions. This is it. I'll think about it a little more.
Definitely. These perspectives obviously open up a lot, and they also open up a lot of ideas. Some of these things can be done.
See, Mustafa, some of these things can be done without too much change to the system. And another thing, you see, one judge comes, one judge goes, then one judge who's heard the matters suddenly goes away. Special trial cases, there is no designated judge appointed. People are languishing in jail. So for all of these reasons, whatever the reasons for the administration, whatever the reasons for the police, there must be an upper limit for custody, even in serious cases. Why not? I mean, how serious can they be if you're just not doing anything about it? And often the process becomes a punishment. You feel that you may not succeed in actual prosecution, let them languish in jail, fine, but how long? I know of many cases where people are there on the basis of material which cannot be dignified as evidence. They've not got bail because they're POTA cases. Years on end, they're in jail. I mean, that is no solution to terrorism. Right?
Yeah. That's true, yes, ma'am. Okay, so just on those lines, the few acts nowadays that we're in discussion, the UAPA, the Security Act, for example, the POTA, the TADA, the MACOCA, etc. So these legislations in a way make it very cumbersome for the accused in the entire process, as you even mentioned. So how do you feel the role of the police system, one, under these legislations, and the role of the judiciary? How can that be changed? How do you feel that it goes wrong on the accused, and what transformations could be brought to these legislations per se?
First, I don't think this legislation should be there at all. Let me qualify that. See, it makes sense to have a different classification of an offense, which is a terror offense. Terror, I would say. It's not the same thing as murder. It may even make sense to give some additional time for investigating and filing a charge sheet. But it makes no sense to dilute evidentiary standards in these laws. POTA doesn't have it anymore, but MACOCA has it. Now, why should you, once you've caught somebody, see the law, the procedure otherwise kicks in only when you've caught somebody. So once you've caught that person, there is no reason why the normal law should not apply. What has happened with years and years of having these special legislations which go against the grain of criminal jurisprudence is systems have become incapable of applying the normal norms of criminal jurisprudence. You have confessions to police officers, you have bail, not jail, not bail. And you have, for instance, there are offenses which carry from 5 years to life imprisonment. So they cannot get bail because it's punishable with life. Although in the ultimate analysis, they may be punished only with 5 years. So this process has really done something to our criminal justice system. It has, the police is overworked and under-equipped. Not special agencies, they are not, but in general, the police is. And that perhaps explains part of it, but it is not either a justification or an explanation for the rest of it, which is that has made them so complacent that they rely almost entirely on custodial abuse to bolster a case. Obviously, there are exceptions, but they rely on this to bolster a case. And, courts have also been overwhelmed by this discursive management of a nation in peril. And we have faced it. We face it every time when we deal with, bail application, where only material is inadmissible statements, but they say, no, these are matters for the trial. So this has seeped into the judiciary. Now, I can't wave it away with a magic wand. We only try and engage with this, but one thing is to be cognizant of this. And this discursive management, so you just see them bringing material either based on custodial statements or when they're admissible custodial confession, very seldom. Or they say they see something they don't follow any norms while seizing electronic evidence. They just pick up anybody and everybody's computer, the whole family's computer, take it away. There is no notion. So you see, they have slack, but their shoddiness, their failure to observe due process, a lot of it gets brushed under the carpet. We see this all the time in these processes because somewhere there is that these people are fighting for the nation's integrity. So there's a discursive management of all of that. You see that in their charge sheets. Such broad brush statements, such, kind of pointless, inferentially fallacious case. So the rigors of proper investigation, they manage to escape because of this kind of discursive management. This is something that we see. if you want to know what are the answers to this, one is I think that they should not be permitted so many legal, there's such a wide leeway legally, because the purpose is not, because it's not dealing with terrorism in the sense of, dealing with politically with terrorism or security. You've caught a person, so why can you not follow normal criminal due process? So that I hope the courts will understand. And two, these difficult bail provisions of showing that there is no prima facie case, that we're all attempting that there should be a more humanitarian, human rights-based, due process-based interpretation of that. When we get that kind of relief from certain courts, we're happy, but it's not become a national phenomenon at all. So that is a problem. And I don't think, the solution will have to come by dealing with bringing this logic to bear on the judges, that the policemen have to be called to account for irresponsible, arraigning of people as the accused. The consequence, as I said, costs or whatever, only that will stop. But if the social discourse, if the judicial discourse, and everybody gets taken in by this discursive management of terror and national security, then things will be bad as they are.
All right. So just now your personal perspective once again, how has the pandemic affected our criminal justice system right now in terms of how cases are going forward and how prisoners are being dealt with? So anything that you would like to share with us on that? How has it affected you personally in your practice? And how do you think things will go forward from here?
I come later. It's had a dismal effect on the criminal justice system. Bail cases are not being heard. Trials are not going forward. Because although there was relief to some sets of prisoners, see, people accused of anything over 7 years, terror cases, they have been held to be categories which are not entitled to this relief. Frankly, it does not make sense to me, because if the purpose is to prevent health hazards, then how do making out these categories, COVID is as bad for a TADA accused or a POTA accused or a UAP accused as it is for anybody else. So the fact that courts are not moving forward, even bail applications are not being heard for days on end, obviously it's having a dreadful effect on the criminal justice system. I do like to go to court, and video conferencing is not quite the same. You can do it from the comfort of your office or your home, but it's not quite the same. But forget me. The criminal justice system, as it is, things are not moving. As it is, people are in jail for long spells of time, especially in cases of this nature. And then they don't move. They don't get to see their families, especially outstation prisoners. As it is, it's so difficult for families to come meet them for a few minutes, half an hour, maybe once a month, twice a month. And now even that is not possible. Of course, they're saying there are video conferencing facilities and they're talking through video. So some attempt is being made, but the effect in the criminal justice system as a whole has been quite bad.
Okay, so just now that we've come to the end of this discussion, a small question about you and your practice and your personal life. How do you take time out to do recreational leisure activities in this very serious sort of profession that you have, practicing day in and day out? So what are the things which you do in order to keep yourself occupied, in order to keep yourself engaged? This is there's just been asked by a few of the
24 hours in a day, 7
days
days a week, 12 months a year. There's heaps of time to do everything else. Me, I do crosswords, I do puzzles, I read what I like, I watch cricket, I love cricket, music. I like maths, I like physics.
Okay, I think this will just go on.
Like anybody else, it's not like, if you're seeing me as some crusading, avenging angel of justice, perennially dedicated to the law, it's not the case. Sorry to disappoint you, but that's not the case at all.
I don't know if everyone holds the same view as this, but others do have
this is my view. I think that I have lots of fun. And the legal profession itself, offers you so much to laugh with and so much to laugh at, not the least one's own self. Life itself is so full of the ridiculous that there is so much to have fun about. And if all else fails, there's always Woodhouse. So.
Okay, so just to end this conversation that we had today, the current wave of media trials going on TV right now, the entire Sushant Singh, the entire case that happened there, then the entire Bollywood being involved, a lot of angles, a lot of perspectives. What do you have to say how that has changed how we look at criminal law today and how things are going to go forward according to you? What do you think about this entire thing going on in the country right now?
See, going forward, I don't know, but this toss-up between the right of the media and fair trial, it's a perennial question. Sahara dealt with it, so many cases. And I would, by and large, I'm opposed to bans. However, when it affects the rights of somebody in custody, especially in serious cases, and reporting goes beyond reporting. Virtually, it is like building up mob hysteria against anybody. It can be saying they must go to jail. They must go to jail. I think questions will be asked, and they're being asked. But still, while I understand why this process is happening, I am also full of trepidation about broad brush guidelines, because really it is really a matter of a case-to-case basis where a court's conscience, that too as was held in Sahara, the court of record, a High Court and Supreme Court, that postponement orders from time to time. Because the more you give general guidelines, the more it becomes difficult to interpret, and again you're back. Somebody who's affected by that publicity is saying there should not be this kind of publicity. Somebody on the other side, the media side, is saying it is our right. So of course, there is a certain kind of publicity which is unacceptable. Courts can only juggle this on a case-to-case basis, and it's good because this had to come. They were doing this in terror cases. They were going at us during the Parliament attack case, that we argued against the death penalty. Various media channels, personally attacked me at that time, which I ignored. But so I'm glad that they're being called to account for irresponsible, excessive reporting and usurping the role of the police and the judiciary. They have to answer. They're as accountable as anybody else. But I have some issues about demanding from the media the source of their information. Section 15(2) of the Press Council Act protects it. It is called the newspaper rule also. And there's some judgment saying when national security is involved, perhaps a court can breach it. So I'm worried about swinging the other way. I can understand a case-to-case ascertainment. I can even understand the suggestion that the cable TV network, monitor, whoever, must not permit certain things. But to make general propositions one way or the other goes against the nature of the issue, which is always one of delicate balance on a case-to-case basis. So if you ask me what my views are, these are my views, that at any given point of time, because some of the cases, you see, in some cases, it is publicity that has forced investigation and forced a fair trial. And in other cases, it's publicity which has vitiated it. And both are true. So I don't think a single proposition is possible in these circumstances. But yes, I think that the media is being called to account, especially the visual media, has gone overboard in recent times. And I'm glad it's being called to account. And that's all I will say.
Ma'am, we just have one question from the chat box on YouTube that we are live right now on. Could we just have that and then we could wrap this interview up?
Sure.
So the question is that, do you think custodial violence / police brutality is an attempt to reach the idealistic distortion of realism by partake of the view of law? And on those lines, the question, follow-up question is that, do policemen face any departmental action for the same? And furthermore, do they face any departmental action for having FIRs quashed?
I didn't understand the first part of the question. In fact, I had already suggested to you all to eschew bombast and please explain it to me. The second and third, they should face, but not enough. They ought to face, but not enough. They don't face it enough. Victims of custodial abuse often have to go to court, get orders, get directives, and even then, I have a whole chart of cases, so it is really not enough. For getting FIRs quashed, I'm not sure. I think much less. I don't see also that every time unless it can be shown that it was actuated by malice, he was demanding a bribe, then of course there can be a departmental action. But simplicity, because an FIR is quashed, I don't know where the departmental action would lie. But they ought to face for custodial abuse, and they don't. Now, will you explain the first sentence?
The first question, it's more about the idea of how police brutality. I think this was even dealt by you in the question where you answered about the Makoka, that how.
Then what is the question?
The question is more in the lines of that, is police brutality or custodial violence an attempt to reach the idealistic distortion of realism of the view of law? I think the question is
idealistic distortion of realism. I think police brutality it's just the nature of custody. It is so opaque. And power corrupts, and power corrupts absolutely. So the power that a person has over someone in custody, there is no law that can reach there. There is no directive of the Supreme Court that enters it, though it may be there outside on the walls of the police station. That power is absolute. The only way you can civilize that power is by ensuring subsequently that there are consequences for this. I would not attribute any great teleological purpose to torture. I think it is an aspect of brutality greatly enhanced by immunity and impunity, because systems do not punish this enough, not enough. They may be broad, they may be very, very wide-ranging, they may be very pious statements of the law, but in the actual working, I don't think a policeman who is who's indulging in torture really feels that he's going to be called to account for it, because from the magistracy, and it's such a burden on the victim to establish there was torture, then establish, so that is what really the magistracy should check. And that impunity is what higher courts should check. Whether it's whether it is an idealistic distortion of realism, I don't know. I've really not understood the question. You can explain it to me.
I think there's a little confusion with how the question was framed, but I think this answer really gives us a good idea about how things take place on a practical basis in the country.
I hope so. I must apologize to the person who raised the query, because I really didn't understand the first part. Read it again. Just read it again. I want to hear it again.
I'll just read the question verbatim once again.
Yeah.
Do you think custodial violence / police brutality is an attempt to reach the idealistic distortion of realism by partake of the view of law?
Anyway, I've summarized what I feel about why there is custodial violence. And it's also there because, you see, there is a social acceptance of it as somewhere inevitable for law enforcement, which is nonsense. Because if you have that kind of power, then you're more likely to, compel a certain view. You arrested somebody, so willy-nilly you build a case against them. Whether it is true or not, it exempts the police from backbreaking investigation. So it does not really serve any law enforcement purpose. By and large, people believe that it still serves a certain purpose. So there is a teleology to it, which people ascribe to it, which really I don't think has any basis in fact. But that's what I feel. I hope it somewhat answers her or his question.
Okay, so with this, thank you, ma'am. We will wrap up this discussion. It was great to hear a lot of things, a lot of takeaways from today's discussion, a lot for students like us to pick up for once we move forward into practice in the future, a lot for us to ponder upon, a lot for us to work upon in this field. So thank you so much once again for taking your time out on this.
I was delighted to be here, Mustafa. Thank you very much for all your kind words, and thank you for talking to me. I was very happy to be here.
All right. So with this, we'll end the stream now. Thank you so much.
Bye-bye.
Yeah, the stream is over, ma'am. So now it's only us on the call.